Everybody, Robert Wright here, and thank you so much for taking me up on my offer to kind of pay it forward and kind of walk through the direct hit search process over at the USPTO. Really appreciate all the awesome feedback and certainly all the kind comments. I'm not deserving of any of that, but very much appreciated. Before we begin, before we head over to the USPTO, 2 points that I want to raise to you. First, trademarks do not exist in a vacuum. They only exist once you've attached them to a good or a service. So as I went through the list and kind of pulled the marks that you guys wanted me to search, I'm searching them in the abstract. So for example, the first mark that I saw was TerraBabe. Well, just looking at that in association without a good or a service, it's not going to tell me much. Now, if you tell me TerraBabe and I'm selling toe socks, okay, that tells me something, and that's going to be important. The good that we're associating with it or the service that we're associating with the mark is super important, especially if we go to the database and we find that there are other marks that are similar that already exist, okay? Secondly, as you all think about branding for your private labels, think about the spectrum of distinctiveness. Now, I've pulled this, I just literally Googled trademark types of trademarks and then did an image search because I didn't have an image ready to go kind of talking you through the spectrum, but you can see that there are essentially 5 types of trademarks. There are fanciful trademarks, there are arbitrary marks, there are suggestive marks, there are descriptive marks, there are generic marks. The higher up to the closer to fanciful you are, the better. And an example of fanciful would be Kodak, for example. I mean, Kodak has a meaning that doesn't mean anything absent its association with film and photography, right? So the folks at Kodak did a really good job of making sure that when someone says Kodak, you immediately think photography, right? On the complete other end of the spectrum is something that's generic. Xerox, aspirin, Kleenex. These are all terms that, even though some of them were once trademarks, they attempted to distinguish certain goods and services from everybody else's in the marketplace. They did too good of a job, right? So that everyone who started grabbing for tissue said, give me a Kleenex. Everyone who wanted to go make a copy said, I need to go get a Xerox. Okay, you don't want to be generic. You don't want to be descriptive. So if you're selling toe socks, you don't want to call them toe socks. You don't want to call them toesies. You don't want to call them super socks or soft socks, for example. You don't want to be descriptive. And the reason you don't is because the nature and purpose of a trademark is this. It attempts to distinguish your goods or services from everybody else's in the marketplace. And unless your mark is fanciful or it's arbitrary or suggestive, that's kind of a little bit of a tweener there, but unless it's fanciful and arbitrary, it really can't do that. If something's descriptive, if something's generic, it's not functioning as a trademark. It's not describing, it's not distinguishing your goods from everybody else's. So just, a couple things to be mindful of as we go and search. So that said, I'm going to go over here to uspto.gov. And I'm just doing a US search. You can do international searches as well, but you guys get a US search because I'm in the US. So we'll go up here, we'll go to trademarks. We will go to search trademarks. And we will move down here and you can see, we don't want to fill out a survey. The PTO has something called the Trademark Electronic Search System, or TESS. This is what we're going to use to search for our trademark. I'm going to click the hyperlink, and then I always suggest just doing a basic word mark search. Okay. So here let me run it on something that we actually know about, so you can kind of see some populated. Well, yeah. So let's do Nike. You can see that there are 157 records for Nike. Nike has a lot of trademarks. We could click in here. Well, actually, let's go back for a second. You can see that the chart that's generated has a couple of columns. So there's a serial number. That's not really going to mean much to you. There's a registration number. It's not really going to mean much to you. There's the word mark piece, which is going to mean, that's going to tell you what the trademark that's protected or in the application process actually is. Ignore the check status, and then you can see live or dead. If live shows that means that the application it's either on the books or it's in the process of being on the books. If it is dead, that means that the trademark, for whatever reason, there was an application made and it is now dead. It no longer is on the books, meaning it either didn't pass muster with the examining attorney who was taking a look at it and it got rejected. It was on the books, but then it didn't get renewed. There are a number of reasons that trademarks can become dead, but that's a good indicator. If you see something live, definitely have to pay attention to it. Frankly, if you see something dead, I'm always curious about those too, because that tells me, maybe I'm going to have some challenges if I'm registering a particular mark. So I can see what happened to one that was pretty similar. So let's go back and let's see. First mark that I got was TerraBabe. TerraBabe. I'm literally just going to type that in and let's see what happens. Nothing. No TES, no test records were found. So that means no one has taken that term. Now, I wonder if anyone has taken Babe, because ultimately whether or not you can use a mark or not is whether or not your mark is going to be confusingly similar to someone else's. So let's see what has been registered under Babe. Oh my goodness, over 1,000 records with Babe. You got Babes with Coffee, Trucker Babe, Bundle Babe, Beach Babe, Boss Babe, Mermaid Babe, all sorts of babes. So, TerraBabe, is it taken? No. Direct hit search says no. You can use TerraBabe. Depending upon the nature of the goods or services, it might be that I start looking into these babes a little bit to see if there's anything that might be somewhat similar. Let's see if there's anything for Terra. And there's a lot of Terras too. Terra Peak, Terra Fuzz, Hands of Terra, and you can see most of these are live. So, if I knew what the good or service was going to be, what I might do is go up here and do a structured search. And I'm going to search Terra in do a drop down here. Where is there we go. In the mark. And then I'm going to search Terra as part of the mark. And let's say, what are we going to register that and associate it with? We're going to socks. I don't know why I'm using socks as an example, but that feels like a good thing to do today. So Terra is part of the actual mark itself in association with the product socks. Anything? Hey, look, we got a couple. Then I would start going through these and saying, okay, are any of these similar to TerraBabe? Terra in Sky, Terra Lab, Terra Weave, Terra Firma, Polyterra, Terra Blue, Terra by Camper? No. And frankly, look at these. Most of these are dead. So that's good news. So can you use it? Yeah, and see, here you go. You click into the application and you can see Terra and Sky, they have registered and associated with class 25, all sorts of things, shoes, sandals, slips, half slips, and socks. And it's also a Walmart store, something I would want to be mindful of too, because I suspect that Walmart has deep pockets to be able to go after people whose marks are even somewhat kind of similar. So on its face, TerraBabe looks fine. I'm not seeing anything in here that's making me say no, but I also don't know the goods and services. So we'd have to be mindful of that. Let's go to Snuggle Rabbit. Direct hit search, there is nothing on the books for Snuggle Rabbit. I am guessing there is something on the books for Snuggle. And there are 409 records. Snuggle Pod, Snuggle Glove, Snuggle Buddy, Snuggle Puff, Snuggle Moose. Okay, so a moose is an animal. It's kind of like a rabbit. Maybe that's confusingly similar. Let's see, this guy, it's alive. Snuggle Moose in association with storybooks. Okay, so if you're not doing storybooks, I wouldn't even sweat that one. The Snuggle is real. The Snuggle is real. I like that one. Let's see what that guy is. That is for one-piece garments for children, t-shirts, and tank tops, not tank shops. Neat little thing. Let's click and see what their specimen is. This is always the fun part. So their specimen, we actually see their product. There you go. The Snuggle is real. Beautiful. Someone's selling on Etsy. I have to get that for my youngest daughter. I think she would appreciate that. All right, click out of that. All right, so Snuggle Rabbit, didn't see anything, no direct hit search. I would also search Rabbit. 12,000 records to go through, all sorts of things. Jackrabbit, Lucky Rabbit, White Rabbit. But direct hit search, you're clear. Nothing on the books for Snuggle Rabbit. Do another basic word search, and L.A. Jane, nothing. That's a great example of, I mean, that's a Kodak right there. I'm not familiar with that actually being a term. So that's a great trademark and really one of the ones that you would want to go with because you're going to have an easy registration process. Simply Poppies. Simply Poppies. Nope, nothing there. So you guys have come up with some pretty good marks. Now, if we just search Simply, you can see there's all sorts of Simplies. Simply Coconut Nuggets, Simply Cinnamon, Simply Prepared, Simply Natural, Simply Complex. My concern with Simply Poppies, you know, if you're using it, and again, let's go over to the spectrum. If you're using it as an apple, Simply Poppies in association with shoes, probably okay. If it's something that's more flower related, well, then that might be, I'm not saying it's impossible for it to be a good trademark, but you're probably going to get a challenge from the PTO. So just be mindful of that as you kind of think about, do I want to move forward with Simply Poppies? And then the last one on here, let me see. It was Catch. I'm thinking that's another Kodak, but let's see. Oh, no, look, here we go. Catch. So this one was canceled. Okay, it looks like these folks, so Karen Echeverria, tried to register this. Now that's a point that you should bring up. All the information that you put into the PTO database is publicly available. So if you don't want your private address to be out there, use an attorney to register for you so that they can use their firm address as kind of the correspondence address. That's what I'll do for clients so that they don't get all the junk mail and all the unsolicited stuff. You get a ton, believe it or not. So these folks tried to register this in association with scrapbook materials. They were selling a kit comprising of a printed guide to assist the user in preparing the scrapbook. And they registered the mark in a very stylized form. Looks like they tried to register in 2007. In 2008, it was published for opposition. And it looks like it was actually registered. So let's see why it was canceled in 2015. So let's see why. Let's go in here into the history. And you can see the registration was canceled because the registrant did not file an acceptable declaration under Section 8. So let's see. There we go. You can see that they had several office actions. They went back and forth with the examining attorney. Finally got it. Let's see. So there was an office action that went out. Let's see. The identification of goods was indefinite. It needed to be clarified. The specimen wasn't good enough. Okay, so the examining attorney was finding a lot of issues with this. And then there was a note to the file. That's not particular. Returned applicant's call. All right, so the applicant evidently called and said, hey, what's going on with this final thing? And then they called about the specimen. There you go. There's an example of the specimen that came in. And then there was a reconsideration. All right, so there's a lot of stuff going on here. Notice of publication. They finally get published. There's a registration certificate that gets on the book. And then they ultimately just didn't follow back up with it and prove continuing use. So I guess they just walked away from it. So there you go, Catch. Now, can you use it? Yes, because this application is dead. Can you Are you going to have some difficulties using it? Possibly. What I would really do is go back in these office actions to figure out what the PTO was concerned about here. The specimen was bad. That's easy enough to overcome. So it looks like Karen maybe filed this on her own. And if she were a little more familiar with trademark law, she would have been able to get the specimen that they needed. But it looks like it was more of a procedural type thing than a substantive type thing. So certainly, as you go forward with Kevin, I guess it was you, catch, yeah, you can register it. It's been registered before for scrapbooking type stuff. So maybe move away from that, because even though there's not a federal registration on the books, it could be that those folks are still out there using it. But you could swoop in and maybe get a federal registration for those books, and maybe get some superior rights. So there you go. That is, man, I walked through that. I hope that was helpful. If it wasn't, shoot me back questions and I'll answer them. But that's really, a pretty basic way to go in and do a search and see if the mark that you've chosen is one that's already on the books or not. So I hope that helps, and I'll see you soon. Ask questions.